Okay, fantastic. Avoiding H-1B RFEs. We finally got it. Thank you for your patience. So the common H-1B RFEs are either special occupation, availability of work, and beneficiary qualifications. So those are the key ones that we're going to be going over, especially now, you know, with the CAP season just getting started. This is some of the issues that will come up. So let's start with the first. Definition of specialty occupation. It requires, the definition in the regulations is that it requires a theoretical and practical application of a body of highly specialized knowledge, requiring the attainment of a bachelor's degree or higher in a specific specialty or its equivalent as minimum entry. So the issue becomes, does this, so when they say specialty occupation, that doesn't always mean that they're questioning whether your degree is equivalent to a US bachelor's degree. They're just questioning whether either that the work that you're doing at a minimum requires somebody with a bachelor's degree, or that your degree is related to the work you're going to be doing. So the devil is in the details. It's really important that job descriptions are not generic. You know, usually when you post a job on Monster or for work to, you know, find someone as a job posting, you know, you're a little more general in the terms. Here, you want to make sure that you kind of make it very obvious the correlation with your education and what exactly the work that you're going to be doing. So that's really critical. And specialty occupation criteria. Now, previously, you only had to meet one of the 4 criteria. As I said, during the Trump administration, they really did a number on a lot of the adjudications. And so one of the things that they've said is it's not just one, it is, you got to show all 4. Now, we have always tried to prove all 4 anyway. So that hasn't been an issue for us, but it really is something that's very important. So you have to show that a bachelor's degree or higher is normally the minimum requirement for entry into the profession. So how do you do that? Maybe articles, but they have to be articles from, you know, well-known publications, or showing that, and you could, there's one type of evidence that you can use for a couple of these criteria. So showing job postings for companies that have, you know, the same size as the company that is the petitioner, showing that they also require a bachelor's degree. So, and there are other times where the university will, for the degree program, will talk about, you know, what that degree program will provide. So those are all ways in which you can show that it's normally minimum requirement for entry into the position. A degree is so common in the industry, in similar positions, in similar organizations, or the position is so complex and unique that it can only be performed by an individual with a degree. Again, you can use those job postings showing, but remember it says similar positions in similar organizations. So it's not enough that you just show job postings, but you've got to show that those, so it takes some work. You've got to show that those organizations, those companies are similar to your organization. There's a lot of information on online about the size of those companies. So that's a way in which you can prove it. You can also show criteria number 3, that the employer normally requires a degree or its equivalent for the position. But remember, the key is, this is where the biggest problem comes in, is sometimes the employer has employees for that position, let's say it's software engineer, that have a variety of different types of degrees. But if you can show a correlation, even if they're not the exact same degree program, that the skills that they've obtained in these various degrees are the same, then you can still use that to show that the employer normally requires a degree. And, you know, you'd have to show the employer's payroll to show who he's paying. So that means these are the people that are working for him or her. And then you would have to show proof that those individuals are in the same position and have the same degree. And then 4, the nature of the specific duties are so specialized and complex that the knowledge required to perform those duties is associated with the attainment of a bachelor's degree. And again, we usually use articles. We talk about how the average person, let's say, for example, if you are developing a complex application for a legacy system, you know, if you're just a programmer, you wouldn't be able to do that software development of that application. So kind of making that distinction. So these are the critical issues for specialty occupation criteria. And next, we will talk about, ta-da, employer-employee relationship. So what does that mean? This is, there are 2 types of employment. One is deemed traditional employment. Traditional employment is where Challa law is sponsoring an H-1B employee and the employee is working at Challa law for Challa law directly. That is traditional employment. For that, you don't need to show employer-employee relationship. Where the employee is placed at a third-party site, that's when they question whether there's an employee-employer relationship. Is the employer able to control the work of the employee? And you have to show, you know, a variety of issues that are outlined actually from the IRS, that it's an employee-employer relationship, like direct supervision. So let's say you're at a third-party site. How do you show direct supervision? Well, your company may have a project management software that you all utilize. And so that someone from the petitioner's office is monitoring. You may have weekly meetings. And if you do that, you want to make sure that you document those. So if you're at a third-party site, it's critical that the person that's supervising you is someone from the petitioning employer. Maybe an organization chart that shows that, you know, the employer is, you know, here's the tier of supervisory roles. Tools and resources. Is your employer providing a laptop? Are they providing a phone? Do they have some proprietary tools that you are utilizing? And so that would be all the issues that would come up. And then employee benefits. Are they paying for your health care, 401k? Do you have paid leave? You know, all those things would demonstrate that there is an employer-employee relationship. Not one thing. The more you can provide, the better, especially, like I said, if you're at a third-party site. And then the availability of work. Now, the regulations state that you just have to have anticipated work and not speculative. Speculative is, hey, I have no basis, I'm just making a speculation. If it's anticipated, you're making that premise based on you know, previous history. Okay, so for example, a lot of times when there's a job order, because remember, if you were working at a third-party site, they want to show that there's availability of work. So there'll be master service agreements. But with the master service agreements, there'll be job orders. Job orders are never for longer than usually 3 months or 6 months. So if you can show that that company has historically been renewing it, that would show that it's not speculative, but it's anticipated. And detailed work assignments, you know, even talking about the project itself that you're working on, and you know, what the project plan is, and, you know, getting letters from the end client that states that it is anticipated that this employee will be working on this project for, you know, 3 years. So it not only do you have to have it, but you should have it for the duration. There's for all the things that we have talked about, you know, there are court cases on this that have been sustained by the current Biden administration. So those are governing, but there are some people that are still in USCIS from the previous administration. So we want to kind of make sure that in case, you know, some residual RFEs come in, that you're equipped to handle it. The H-1B must be qualified to perform the services or engage in specialty occupation. So the important thing is, like I said, the devil is in the details. You've got to make sure that you connect the beneficiary's qualifications to the work that they'll be doing. You can do that with some of the courses that they've had, some training, some experience, and that's a great way in which you can make that correlation. Right, and so sometimes, you know, what we do is usually you get a credentials evaluation when somebody has a foreign degree. There are other times where a person may have a degree in, let's say, electrical engineering, but they've got maybe 10 years of experience doing software development work. So there are times that we will get a credentials evaluation to show that the education and experience is equivalent to a degree that would be related into the occupation. And next, I-140 challenges. For those of you who have I-140s pending, we've talked about this before, but I thought it was important that we highlight it. That the qualification, that you meet the qualification for the requested category, that you've got the education or experience that was outlined in the firm, and that the employer has ability to pay. Those are the most common RFE issues. So the position in the labor certification must qualify for the requested category, minimum education and minimum experience. Recently, we've been sent cases from that were prepared by other employers, and I was astounded at the sloppiness of the work. So some of the things that other law firms were doing was, number one, putting a different job title versus what was proposed throughout, not ensuring that, you know, they clearly outlined what the beneficiaries' education and experience is. Like, for example, EB2. You can qualify for either EB2 or EB3 if it is greater than a bachelor's degree. So you could qualify for both. And the issue becomes, remember, for purposes of the I-140, EB2 you can qualify for an EB2 if you have a bachelor's degree plus 5 years of progressive experience. So, but the 5 years of progressive experience, in addition to that, you have to have the equivalent of a bachelor's degree. Now, there are some institutions, especially in India, where a lot of the degree programs are 3-year degrees. Whereas in the H-1B, you can show years of experience to get that 4th year to qualify for a bachelor's degree equivalent. You can't do that in the I-140 realm. What you can do is you can show that you've got a multiple, you know, various degree programs, and that can be equivalent to a bachelor's degree. But they have to be, those degree programs have got to be, you know, for any of us that have traveled to India or lived there, you know that there's, you can throw a stone. You can't throw a stone without hitting some type of higher education school. Not all of them are, valid. So you want to make sure that the degree program, and we have used EDGE, that's what the USCIS uses, and maybe, and get a credentials evaluator to state that those various degree programs are equivalent to a bachelor's degree. And then you have that 5 years of progressive experience. Now, the progressive experience, the experience requirement, we always like to try to get those experience letters before we file the perm, because inevitably people tell me that they can get it, but they can't. And that's really critical. So you have to have it should be on letterhead. It should be signed by someone who has firsthand knowledge of the work you were doing. It should also state in great detail the type of work that you were doing there, not just in general terms. The period of time that you were there, your job title, all those things need to be provided. Otherwise, you could come and enter into trouble. So there's the degree, making sure that the degree is what was required for the perm, and then making sure that you have the experience letters, whether it's for the 5 years progressive experience or if it's for any of the special requirements that were outlined. Like if they said you needed .NET experience, 3 years of .NET experience. Well, where did you get 3 years of .NET experience? And a lot of times, this is what also that's why I like to see the letters up front. People will fill out their experience, and later on, they will say, oh, but I got that .NET experience someplace else, a place that wasn't listed on the perm. You want to make sure that whatever experience letter you're going to use, that you highlight that in the perm. Even though the perm only asks for 5 years, you may want to do that in the addendum and make sure that you put that where you got that experience in the perm itself. And next, we're going to talk about, boom, it's loading. You have to have that, you have to have met that experience requirement. Number one, it is only in limited circumstances that you can use the experience gained with your petitioning employer. You can, I'm not saying you can't. If you can show that you're in a different position where 50% of the work that you're doing is not similar to what you were doing before. So let's say you've been with the employer a long time. You started out as a software developer. You're now a senior project lead. So you're not really doing the software development anymore. But you have to have knowledge of that to do the work that you're doing now. You may be able to use the experience gained with that employer. But you have to show that you gained that experience before you filed the perm. It is, you can't show that experience after you filed the perm. So that's why it says before the priority date. And documentation of closely related degrees, length of degree programs, and the experience letters, and making sure that whatever it is you're going to show at the I-140 stage, that your perm is almost a mirror of that. So that's why it's important that we kind of make sure that we don't just file the perm in isolation as a silo. We file the perm thinking about stage 2 at the I-140 and stage 3 at the I-485. Ability to pay. Now, the employer can show the ability to pay. They've got to show it from the time the labor certification was filed until the green card is approved. But from a practical matter, it's from the time the I-140 is filed until the time the I-140 is filed. Now, if you did a downgrade and you filed a new petition, you've got to show it from the time the priority date which means where your perm was filed, up till the time that you're filing the new I-140. Anytime you file an I-140, you've got to show ability to pay. And the way you do that, there are a couple of ways. Number one, the biggest way is, if you have been paid the prevailing wage. So whatever the wage, because remember you get a prevailing wage for the perm, whatever that wage that's stated on the perm application, if that's the wage you've been paid, and maybe even more, you can show your W-2s, pay stubs, and even if the employer's tax return is negative, it's still okay. That is all you need to show ability to pay. You can show ability to pay. The other way is through the net income of the petitioner. If the petitioner has net current income, then you can show that. And then there's the net current assets. And you can use a combination. Let's say the prevailing wage is $75,000, but you have been paid only $60,000. So you submit your pay stubs and you show that you've been paid $60,000. There is that $15,000 that we have to show ability to pay in some other area. Let's say the net current assets are $5,000. Okay, you can use the net current $5,000 as the net current assets. And then if the net income is $10,000, for each of the years from the filing of the perm to the time you're filing the I-140, then you can show ability to pay. And every year you can show something else. Maybe in the first couple of years, especially if you did a downgrade, the first couple of years you weren't making the 75. So you can show a combination of these for those years. And then later you were being paid 75. For those years, you can show your W-2s. But you would have to show this, so that analysis has to take place for each year up to the time the I-140 is filed. And next, so your I-140 is approved. What's going on with the I-485s? Continued employment authorization, medical exam forms, documentation for identity and relationships. So continued employment authorization. Remember, after you meet the requirements for AC-21, you can work for yourself. And that is a possibility. And we had a really great YouTube webinar on maybe even leveraging franchises to meet that requirement. And I'm sure Mac will send you a link of that. Then you got to make sure that you had continued employment authorization. So your H-1Bs, EADs, you submit all of that to show that you were in valid status and you had continued employment authorization throughout your time. Medical exams. Medical exams must be submitted to the USCIS within 60 days of signature. And then once it's submitted, it can be used up to 2 years. If the I-45 is pending longer, new medicals may be required. And if you got your medicals after you filed your I-485, you want to keep in mind they're only valid for 60 days. So you may have to get new medicals done if you're waiting for the RFE to resubmit to submit your medicals along with your adjustment. So that's something to keep in mind. Now, the biggest issue is identity and relationships. You have birth certificates with no name. You have missing information, or the birth certificate, you were born in, let's say, 1982, but you just received the birth certificate in 2018. So it was not really around the time that you were born. So they have an issue with that. You may have a different, there's inconsistent information between your passport and your birth certificate. You've got different names that have been used, or your birth certificate didn't contain a name. What you can do is you can use affidavits, to kind of support what the name is. In most Indian families, the name is, you don't have, there's a special naming ceremony. So, people who attended the naming ceremony, you may have your 10th standard examination records that has your name. You may have an Aadhaar card with your identity listed on it. So you can use supporting evidence to kind of overcome any deficiency in the actual birth or birth certificates, either for yourself or for your family members, and even marriage documents. So there are ways in which you can use other information to affirm that. So next week, news roundup. We're going to talk about some of the latest news that for changes that are happening, the geographic restrictions, consular processing, and the H4L2 biometrics being suspended, and new deference guidance to replace the Trump era policies. So you don't want to miss next week, and make sure you share it with your friends so they can know what the latest is on immigration and get those strategies. And then, based on the new guidance that is being issued by the Biden administration, we're going to craft some strategies with, on how you can utilize that and leverage that moving forward. Right now, you want to make sure that, some of the takeaways from today are the medicals. If you've gotten medicals previously, remember they're only valid for 60 days. So you may have to get those again. You may want to look at the evidence that was submitted to show ability to pay, and make sure that your PERM and your I-140 are consistent in terms of your background and education. If you have not joined us, please join our Challa Chats forum. It's a great community that we've created with people who are in similar situations as yourself, that where you can hear about what the processing times are, what other people are experiencing, and we chime in with information about those issues as well. So please check out the forum, and I think Mac is sending you a link to that. Please connect with us on our various social media, share it with your friends. And like I said, we're going to be starting the Facebook Live Q&A, and how that's going to work is we're going to post the event on our Facebook page, and if you share that, then you will be given priority in terms of the Q&A, question and answers. So you get some free time with the attorney. Isn't that great? And make sure you sign up for our YouTube videos. That way you get notification anytime a new video comes up. And if you've been enjoying our weekly webinars, I really apologize for the difficulty in connectivity. I guess this is life, right? You kind of have to go with the flow and do the best that you can. But I thank you for your patience. And you can always email us at info@challalaw.com with any questions that you have if you haven't gotten them answered today. And so I think now we're going to be ready for the Q&A section. So I guess you can stop sharing. Fantastic. And we'll have our moderator joining us, Shaker Challa.
Hello, everybody.
There he is.
Good afternoon.
Hey, Shakes.
Lakshmi, and good afternoon, everybody.
I can't hear you, but I guess, can everybody else hear him? Okay. I don't know why I can't hear him. Let me see. Okay.
Can you hear me now?
Yep, it wasn't on speaker. So.
Okay. All righty, let's get going. Good afternoon, everybody. Hope you're all doing well, keeping yourself safe. Before I forget, I'd like to extend Happy Mother's Day to all of you this coming weekend. Sunday is Mother's Day, so please make, I'm sure you will, and you always have, made effort to take some time and, spend time with your mother and father. All right. Having said that, let's look at your submissions. First one is from an anonymous attendee. My PD is July 2010 in EB2, India with employer A. I moved to employer B 3 years ago on H1B with PD current with previous employer. He wants me to come back. I guess the next one probably is also in continuation. Will employer A be able to run my payroll when the I-485 file is shipped out, or does he need to wait until notice is received? And will it invalidate my current H-1B with employer B?
Okay, good question. And this is a perfect webinar for you to attend, because if you remember what I said, if you're doing a downgrade, one of the things that you have to consider is that can your employer, previous employer, show ability to pay? If you're not going to do a downgrade, you're just going to do the adjustment, then that's okay too. But you want to, if they don't have to do the I-140, then the only issue is going to be, that the employment is actually, it's bona fide. That means you do intend to go back and work for the previous employer. So any communications that you have, emails, maybe a contract that once it's approved, you will work for them, is a way in which you can show that. Now, as long as you continue to work for your H-1B employer, that doesn't, you can have another I-485 pending. That won't affect that. The only way your H-1B would be affected is if you use your EAD to work for somebody other than your H-1B employer. And so there's no requirement that they have to run your payroll, the previous employer, but you just have to, you just have to show that you have the intent to work for that previous employer. That's it.
Okay. Let's get to the next one. Another anonymous attendee. My H-1B transfer was filed on a non-pro-tum basis, and I got an RFE to establish that delay in filing was due to extraordinary circumstances beyond the control of the applicant. But the employee has not otherwise violated his or her non-immigrant status, and that the prospective employee remains a bona fide non-immigrant. I guess that's the statute. How should this be addressed to have my COS from B2, which is pending approvals to H-1B? Keeping in view current situation in India, consular processing is ruled out at this moment. I think I lost her, right? So let's see. Come back and I'll read the question again. But while she is making an effort to come back, just wanted to, share my own personal feeling about what's happening in India, the second largest country in the world, and really feel about, I'm sure many of you who are from India also feel the same. And I hope, the government will, make every effort to turn things around. So I wish all of you, your families out there, and if some of you probably are there now, just to, be cautious, be safe, and be be what do you call proactive in telling your family and friends to be careful and don't need to go out if you don't have to go out, right? And there in India, you get a lot of help, neighbors, family members, So I think they can take turns if they have to go out for shopping, for food, right? So all those things are very important, and you can share how things are done here in the United States for those of you who are there, and just be proactive out there. Protect yourself, protect everybody else. So that's all I can, tell you, wish you, and good luck. And let's hope the IPL comes back, in some time, because
I'm
I feel
back.
sad about the three teams, who got
I'm back. I think
sidelines. She's back.
my
The
phone
boss
is died now. It's not even charging.
okay.
So
It's
I think
charging.
I need a new phone.
Yeah, I said that about a month ago.
Yeah.
Anyway, I was just telling them about situation in India, and so now that you're back, let me read that question again from another anonymous attendee, because I thought you were there, but then I lost you. My H-1B transfer was filed on a non-pro-tug basis and got RFE to establish that, and I think all that delay in filing was due to extraordinary circumstances beyond the control of the applicant, that the employee has not otherwise violated his or her non-immigrant status, and the prospective employee remains a bona fide non-immigrant. I think that's a statute, I guess. So the question here, how should this be addressed to have my COS from B2, which is pending approval, to H-1B? Keeping in view current situation in India, consular processing is ruled out at this moment.
Yeah, we just got it was from another law firm that was working with this company, and we did the nunc pro tunc, and it got approved. So even if it's RFE'd, if it's responded to correctly, you should get a positive outcome from that. If you'd like us to take a look and give you our thoughts on how it should be handled, you can email us at info@challalaw.com. Like I said, we just got a nunc pro tunc approved, and cited, the issues in India, and, actually provided a really good explanation as to why it should be reconsidered, and it was.
All right.
And we were so thrilled. It's for a single mom, so that made me really happy.
Once again, just want to remind you out there, just send questions to the Q&A box and not the chat. I see a question in the chat, or I don't know if it's not complete. It's from Bushra N. That's not complete what you said there. I'm not sure if you were responding to somebody else, but appreciate if you can put whatever question you want to ask in the Q&A box. All right. The next one is another AA. My employer, instead of filing H-1B extension, wants to switch to EAD. My I-140 is pending. How to convince him to continue to use H-1B?
He may not want to extend your H-1B-A for the cost, and also because on an EAD, he can pay you any salary that he wants. But that may be a problem down the road. If there's any question on the adjustment. I always tell people you have to have a safety net. You don't know what's going to happen. Sometimes, the denials are based on a mistake by the USCIS. It's not even that anything's wrong. that they may make a mistake. And if they deny your adjustment, your EAD is invalidated and you can't continue working. It would be an interruption of employment. So it would actually cost your employer more to correct that than it would for them to, file for your H-1B right now. So I think that's a great way in which you can, let them know about why you need to be able to file, the H-1B extension. And remember, for EADs, you only get 180 days from when you file. And whereas with H-1Bs, you get more time than that.
All right. Next one is from Kiran Gangavarapu. Hey, that last name, I got a good friend up in Northern Virginia. I don't know if it's related to him, but here's the question. When can I expect my GC? I filed in October 2020, finished my biometrics and medical. My date is current in EB3.
I would suspect that maybe sometime by mid-summer, you should probably, it just depends on how quickly they're able to ramp up additional resources at the USCIS. Everyone's still dealing with the backlog of last year. So that may be part of, I'm going to see if I can get some insight on that for our webinar next week, because that seems to be a very pressing question. So I've got some contacts at the USCIS, so I will find out when those processing times are. So catch us next week.
All right. Next one, I love the name here. So I'm going to express myself in Hindi a little bit. Next question, Tufan Ali. भाई साहब तूफान अली जबरदस्त नाम है आपका ऐसा तूफान लाइए कि ये सारा कोविड सारा जग से उड़ जाए एक ही झटके में आपके तूफान की वजह से ठीक है ना कोशिश करिए आप. So his question, I have missed earlier presentation videos. Where can I see those?
Mr. Ali, thank you so much for that question. We've got a link, and if you subscribe to our YouTube videos, when we post up videos, maybe not even associated with our webinars, you'll be notified of those new video posts. So please subscribe, and I think our folks will send you a link.
All right. Thank you. Just for those, what I said in Hindi was, the gentleman's name, Tufan Ali. Tufan means is a storm, in Hindi or in Urdu. So I told him, hey, bring such a storm that the COVID just gets off this world in one shot, in one go. So hopefully Mr. Tufan will take care of business for all of us. All right. That's all I have. Kiran Gangavarapu says thank you.
Thank you, guys. And I want to thank my team, as always, for helping us put this webinar together. I want to thank you for your patience, for all the technology issues that I've had today. So, and join us next week for our next week's webinar with all the updates, some insight as to the processing time. Share it with your friends, and join our Telegram community. Like I said, we want to create a community where we're helping one another with immigration. Yes, sir.
I just got a question, so I thought we should. Shiva Mikala, it's a new name, I think, a new person. Welcome. Hi, Lakshmi. My name is Shiva Mikala, and I have a question regarding RFE for I-485 EB3. Priority date is August 2012. I have applied for 485 in October 2020, received biometrics March 2021, and have received an RFE on I-485 regarding discrepancy in name and date of birth with page 1 of I-485 and medical exam. My question is, even though I have birth certificate matching with I-485, why is there a query? Currently, my lawyer has suggested to take 2 affidavits from close relatives. Will it suffice the requirement?
What I want to know is why would the medicals not with the same name that was listed in the I-485?
It says he's got to receive an RFE on I-485 to get discrepancy in name and date of birth with page 1 of I-4 and medical exam. I see both of them.
Yeah. So why is
if you want to answer, Siva, you can answer in the chat. That way I can relay the message to you, to the attorney. Because or maybe he already answered. He said medical is a different RFE, he says.
Okay. So the discrepancy, where is the discrepancy in your I-485? If you said that the birth certificate matches, discrepancy where?
My question, even though I have a birth certificate matching that, why is there a query?
Yeah, but you said that there's a discrepancy. Where is the discrepancy though? I don't understand.
Regarding discrepancy name and date of birth with page 1 of I-485.
Right, that's what I'm saying is, was it input incorrectly?
Yeah, what she's trying to ask you is, you said the birth certificate you have and it matches, but why is there a query? Did you, what do you call, transpose? Like, in US, we have month and date, in India you have date and month. So is that why the query is, or what happened?
Because if there's a discrepancy, that means there's 2 documents that are not matching. So one of the documents is page 1 of your I-485. What is the other document?
It says birth date is page 1. That was the text in RFE. No, it was correct when it was cross-checked. My spouse also had the same query. Birth certificate versus I-485.
Well, I would have to see the email us the RFE. I'm very curious about this because either your attorney made a mistake on your 485 documents, or there's probably some other issue.
Yeah, Shiva, just send an email to info@Challa, because we like to understand exactly what's the issue is. So unless some documentation is shown, share some documentation, then it's easy for the attorneys to respond.
Send me your I-485, what was, the form that was filed, a copy of your birth certificate, and your RFE. If you send me those 3 things, then we'll be able to figure out what's up.
All right, Shiva, sounds good to me. And got one last question. We already are about to close when this question came. So after this question, we will close. But if we couldn't answer your question, please do send an email to info@challalaw.com. This last question is from an AA. Omitting medical records in my initial application for asylum, is it part of the required documents, or is it, or it becomes an issue later?
Yeah, it's when during the time that your asylum, once your asylum is approved, it would take place in that stage.
That's it. Thank you all.
Great. And everyone, hope you have a happy Mother's Day and a safe weekend, and look forward to seeing you next week with all sorts of tips and tricks about what's really happening with the USCIS. So stay tuned for that. And thank you, Shaker, for doing this. And again, thank you for your patience. Bye-bye.
See you all. Bye.